Gregory King sign
Good morning, Your Honor. My name is Marcia, and I have the honor of representing Mr. John Lindsay. With me is my paralegal, my law clerk, Mario Gill, and co-counsel. Okay.
Sean Hoover, I represent James Sheffield. He's a co-defendant on the case, but he is not present. He's the one that's had it arrested.
Where or from the school. Excellent. All right, so we go over a couple of so good morning. Again, because of course, this is one thing that the rules were not present. And then tell me.
Oh, I'm sorry, Judge. They asked us to leave right here, and so you said move up to the front row, but they're kind of reorganizing for us. So they asked us to wait, so we're just standing. Sorry.
All right, so first and foremost. The courtroom is open. There's West South and South. To the extent so to the extent that there are any matters that we need to take up in advance of the jury coming out, please make sure to let my staff know. They will let me know. If you can either send that message or I will. The jury trial, of course, as you all know, this is not my courtroom. Okay, so we have switched courtroom, so this is our little bit different. All right, please forgive me in advance and give me some grace because y'all have all been excellent. It's split. So in my courtroom, the jury is to my right, and the defendants are to my left. So if you see me asking the question on there, it's something, okay? So I'll try to make my point, but that is my comment. All right. discuss, folks removing their mask for the purposes of identification. I don't know if that's during the course of the trial, or you all want to simulate how or whatever it is to do, but that needs to be a conversation, because certainly in this conversation, we have several unnecessary fights, as I call them, about whether or not the defendants will be required to remove their mask. To the extent that you all have that conversation, so that we take that time or we get to the host with it. Okay? So that's first and foremost. Next, as we were informed on Monday, when videos are playing, we cannot talk, right? Because for this, for King's purpose, we cannot look at the video and look at the entire. Okay? So, but the lawyer, if you don't play the video, you make sure that you stop talking while the video is playing and do not start talking again until after the video, after the video. Do not start talking again until after the video has been paused. All right. Now, the court reporter has informed me that because of the courtroom in my car, the witness said that there's a slight issue. So please make sure I give her carte blanche authority to interrupt y'all to the extent that she needs to make sure that she actually the record that she needs to take. Right? The next thing I give them the sign language interpreter, carte blanche authority to tell you all to slow down. You are talking too fast and or to interrupt you to the extent that they need to get something, clarify something or whatever. All right? Okay. Logistics, we tend to take a break every 2 hours or so, okay? I am a very direct person, already late. So if I ask how much time do you have left, or how much do you have to give assistance or something that variation, that is not my way of telling you to move on. That is my way of trying to figure out where you all are so that I can take a break at least as stuff this time as possible, okay? Again, I'm very direct, so when you move on, I'll say move on. I don't want to speak in the text, okay? So to the extent that you have an objection, please make your objection. And if you need confirmation, then certainly I will say that and or ask you all to come up to the room or whatever it may be. Right? With regard to family and friends, please make sure that you are not having any contact with children. Right? If you have some family and friends back in the spectators, please make sure you are not having any contact with children. With regard to today, I did order 75 doors. For Mr. Lewis, I don't know if that the state's updated. They said it's about 3 days. So we got to set up there. I'm assuming I just got the space. The answer was no. So that's what we say before. So I wanted to make sure that you all were made aware that, that you all keep hearing me referring to Monday because on Monday, we fully focus on the thing. All right, Mr. Lewis, you had a motion. I believe you need to make an announcement because the pleading was rejected. So I need you to orally.
So that
And the pleading was rejected, so
what I'm saying.
yes, sir.
Because we did have a motion.
Excellent. All right, so that is taken care of. Now, as I understand, the state filed some new motions yesterday, is that right? Just one new motion, which I have not read, but, certainly I believe all your notices, that motion must be filed, at least 10 days before it comes. Hearing on that before I read that, but I did ask this, Walton to send that.
And here's what it is. File question, the first that, but it was possible to file, 10 days at a time, because, it's not aligned for that during
discussions that I had with Mr. Neto, when these matters of statements were made based on this, I think, very- It is in the current style. Okay.
Like a page and a half, and I'm quick read, so imagine the page and a half, and the page plus the. So, that's the thing, very quickly, but as a kind of working.
I recall something an officer yesterday that conveyed after conversation with the field. I felt it was, send that off with the field fine, the phone center, that's going to offer slight variation of, what the benefit is. And I'm going to talk this up to Mr. in the actions of her job. But I was told, that this, whole page is only being brought because the client, and he would take this, deal with the client, because she's obligated to. Also said, the plaintiff telling clearly, that management, my client was a rightfully named judge. Then she said, I will also tell my client that I'm a safety officer, and that if he did, he is better off to do the trial, field. At this point, I don't think that's a very good strategy, and then I was told that, they're always there. If they're not there, I'm willing to play on the sword. Now, I'm not going to do that stuff. I think he's very passionate about how people are doing their client. That's something important enough, to make this mention of women for an instruction that one, I believe, saying it is elected top, you can take all the proper argument, and that, it must be brought to motion, prior to trial, and that if any such of those actions take place at trial, that for an order, that they abandon the type of actions, they violate the Constitution. That's all.
Understand?
Someone now may please support, Mr. Piles has misstated our conversation, which is one of the main reasons that I'm usually, from my 23 years of experience, unlikely to speak to prosecutors by phone without either one recording their conversations or having a third party present. The allegation that I made a statement about selective prosecution is inaccurate. My statement was that the judicial system is biased against black male, and I stand by that decision or opinion today. During my conversation, I expressed to Mr. Howard that I believe that his offer based on the facts and evidence are an improper offer. However, the offer was I think it was. I think it was based on my communications with Steve. And I expressed to Mr. Howard that the offer was one count on the one for 20 to do 10, and for armed robbery to plead to credit for so I don't think we ever displeased the 20 to serve 10 credit. No, it wasn't 20. It was kind of confusing. It was all over. And it's been moving since yesterday. It's all moving. Thank you. The statement that I believe that this is selective prosecution and that Mr. Lindsay is being prosecuted just because he's black is inaccurate. I believe that the judicial system is racially biased against Mr. Lindsay because he is black. And he's not the only individual, but most of the individuals.
flag, Mr. Lewis's flag, the family flag, King's flag, herself flag, both for the flag, staff flag. So, and all of this will be.
So confirmation as to why the judicial system is so biased and that something.
My point is, what is that? Observing them on here. This is the case where, this is not a case where I want to say there's not any, or right wing about it. If you will recall, I specifically had a movie motion to work. That was in the video. So what I'm doing is what does the race have to do with this constitutional system as a whole, not a whole, not theory, not projection, but the specific facts and circumstances of this case. That is my question, you know, that his statement is that I should not allow you to argue that to the jury. So technically,
My argument to the jury is going to be the selection of a race. I get to bring that up based on that. So the conversation that Mr. Hardman was exactly what we thought. Conjecture back and forth as to why I thought awkward. We're negotiating, we're going back and forth. Race, regarding race, the defendant is permitted by statute to ask questions regarding race. And Mr. Lindsay,
I'm not going to idea, because that's how we're going to out, and I'm specifically addressing that. Y'all will find out very direct, I have very frank, and specific questions for because I don't have to also myself like speaking, because the facts are the facts. And surely, and Mr. Seal, who was a whole lot of focus on the argument, probably got 3 or 4, right there in their cover. But certainly, I'm addressing people who said individually or in to address my specific question. My his statement was that you said that you were going to argue, and this is why your question was there. You said you were going to argue race to the jury. That is
so my exact statement was, I am going to, in my argument, advise the jurors that not just consider the facts, but consider Mr. Lindsay as what. That was my argument. And what is authority? Well, the statute says I can address the issue of race.
not what I'm asking. That's not what I'm asking. And that's not addressing the issue of race. What authority you have that says that it is permissible for you to ask the jury to consider that Mr. Lindsay was white, because the case law is also very clear about a lot of things that can be addressed. However, the case law has narrowed certain things that the statute says that you may do, right? To say that there are things that you cannot do, should not do, may do, etc., even within the statute. So my question is, what authority do you have that says you may ask the jury, because for instance, we all know it's improper to ask the jury to put themselves in the defendant's position. That's improper. So what my statement is, question, what authority do you have that says that you may say to the jury, imagine that Mr. Lindsay is white, because I tell folks all the time, and my staff likes to act like I'm old ladies, and I have all these things to tell you what. I don't remember to be white, I never get it. And so even on this error issue, I keep a very clean file for a reason, right? Because it's not fair to the defendants, it's not fair to the victim's families, it's not fair to anybody for us to just make a mistake. No, our mistake here. Okay, so again, I try very clean, it's basic for me, you can tell me, very direct and clean with my file. Now, error happens, but it's not going to be something it's not going to be something based on something that we pretty much don't see coming, which is why I brought up the math issue when I walked out and saw 2 of the defendants in that. They said, you want me to have a conversation and or present your case file. You're going to argue that the defendant should not have to remove their master purpose of ID. Then you're going to have to do the case file and say that, but that's how I'm understanding the law. So my question to you is, do you have an authority that says you may say to the jury, imagine that Mr. Lindsay is white?
I have authority that says I can say that. I will ask that authority question.
So yes, and you will give it to me.
We're going to be researching that issue for the court, so we can address that for the court before we get to that issue. Also, I want to address the record.
So I want to hear. After the law, so that there's no concern about what my ruling was, about what I said, and so everybody's still clear, okay? Why you also do parts things out, right? If y'all give me 15 arguments, I will take them one by one, very, 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 all right? So you are to make no argument regarding with regard to imagine this room to being white or anything like that until the you have those situations, you have those cases, you take off.
Understood. All right, what's the next issue? The next issue is that council was alleged that I made a statement that I would create error, and that is categorically false. I was coming to that one too, so you're with me, yes? That is false. No statement was ever made by me that I was going to create error, because one, that is unprofessional. Two, that would be a violation of my ethical duty under the state bar rules. So that is false. That no such statement was ever made. I did make the statement to Mr. Howard that errors can be made at trial, and that no case is perfect, and that if errors are made, I am not one of the counsels who is going to pretend as if whatever error the record might show that I've made, that I would not take responsibility for. So when Mr. Hiles is interpreting that to say, Ms. Mino said that she's going to create an error, that is false, and I categorically deny it, because I've never done that, nor would I ever do that. There's no need for that. I've looked at the evidence in this case, and it is weak as my listening.
Well, I think it's a bold statement.
Oh, you'd be surprised when you see it, unless the court has already seen it. Okay.
I saw it when I had. Six cameras was five cameras, five was in there. So again, I understand word for word, right? I get it. You are advocating for your client, devil's advocate, devil's advocate for your client. But I think we also need to be very clear, because I also know, part of the reason both the officers and the driver is the moment, but I want to give them a time. Yeah. And I would tell her or tell me so that I can stop, because otherwise he's not looking at her. And with her being this question, it is this way, sorry. He's not looking at this play. And then if you, so if there's a question that needs to be asked, then stop me. And then I go. That goes for the lawyer as well. If there's any time that y'all need to stop, I'm happy to do so, but I want to make sure that Mr. King is, actively participating in everything, not for everybody. Okay, one of the, so, that's what I was saying. There are five cameras. And again, I'm not making a judgment call on the bill or innocent at all. But my point is, you said it is we your lead. There are five cameras. They are on camera. So that's a bold statement. I'm going to make sure that the record reflects what the record reflects. Because something is, once you got a real strong lead, or once you have somebody else running the messenger. But I remember the Rodney King video that people looked at that video too, and there were different perceptions as to what people were looking at. So when it comes to what the video depicts, I think it's the duty for the state to express to the jury what they think the video depicts, and it's my duty as the defense counsel on behalf of Lindsay to express what we think the video is. I don't disagree with that, but it's my certainly understand the evidence we just picked up. The jury may hear that and interpret one way. He may not understand that that could be passionate, and anyone could see that video and say, oh, yeah. So I just want to make sure, because we're talking about very serious art. And I have calculated it for Mr. Lindsay and Mr. Gibson, but I know Mr. King is facing a lot of years. I'm going to ask what, and I'm going to advise the defendants on record for their case. But I want to make sure they have very clear understanding of the choices that they are making, and have an informed understanding of everything before we proceed. So that's why it's what
And like you said, that you're on, because one of the things we were attempting to do this morning for court, because we all had arrived early, I just want to make sure the record is clear. We were in the back, with the offer had changed again from the state. And I had another 8:30, 8:30. No, nobody was in here yet. After 8:30, we should have given us 30 minutes. But I assumed that, the offer, the last offer that I got yesterday was the same offer. When I arrived this morning, we still had another offer that had been conveyed, that is being conveyed to all. And for the record, I never got an opportunity to address the new offer with Mr. Lindsay in the back when we were there, because we're speaking on 3 different defendants, 3 different counsels, and an interpreter involved in communicating the information back. So unfortunately, although the court, starts at 9, I never got an opportunity to address my client about the new offer that is out communicated this morning, but the offer has been moved since he and I had a conversation. So I just wanted to get clear that. Yeah.
I don't know what offer is, but,
Yeah. And
it is promise, so it's probably, unless y'all. Very, very, this case, that's, so.
it clearly needs to be addressed at this case, because as I stated, Judge, I got it wrong. I didn't ask for it. I thought, and the rules require that if I get one, I can pay. So Mr. House's motion, I've already categorically denied. I said I was coming to a courtroom as a professional and create error. So that my client, that is the most, I'm not gonna say, that is inaccurate. That's inaccurate, and it was never said, and I would never do it. And I am so comfortable with misstate that, to this court, especially when we try to cover it. Some of the communication that Mr. House and I had yesterday were off the record communication. So we were going back and forth and sharing some things, I shared some things, because we're negotiating with the evidence, and we're talking about video, all that stuff. So him to have filed a motion stating that he's trying to perfect the record, I think it's disingenuous, and I think it's assassination of competitor. That's a whole other issue. As it pertains to the mask, I have a special. No, I'm talking about on. I want the record. Okay, that's it. Okay.
Well, also, one of my first questions was certainly. My lawyers don't talk. They just want to first place the court. When they didn't put it as and perhaps.
Well, not necessarily, because discussions could lead to motions of limine where characters being attacked. Yeah, so I just want to show you having a conversation yesterday. I am now standing for the court. We probably be sure. So, can I explain to the court, I wear a mask because I have a special needs type of diabetic.
I say that I was that with regard to the defendants and I that was the specific and I even technical. So I have a problem with that. That I see that some folks are that's fine. However, when it comes to the defendant and when it comes to IP, I mean, if you all have a conversation about that before your conversation can person say, I thought you know because I do give a critical element, right? So that's why I brought it up, so that you all have the conversation, and so that it's not related to file and it's fair. Number 2, so that it doesn't become part of the jury that is necessary and where that's why I'm in the well, and then we're so that's what I'm about the question.
Understood. As it pertains to the 2 issues, I think. There's after the spoken, there's some limitations with what and the jurors would consider Mr. Lindsay as being one. Also, the issue of me creating purposeful error is false and the issue which is masked for stated in filed by the record. And I do not recall any other, statements that, come here.
No, that's the only thing that I was, or it over the ticket.
She said she did say that I was fine.
Well, yeah, that-
And
Oh, I stand behind that. I'm glad you said that. I stand behind that.
I was
Yeah, I'm the rest of these. Alright, so, yeah. When you go to the offer, thank you, ma'am. Alright, so that motion is explained until I get the, briefs and or. The survey will be in spot. Alright, Mr. Let me start with Mr. Steele, because that's the last offer that we got. Off on Monday to Mr. King, the city, so King, and that was one day. That's great, is that all?
So, Your Honor, that is still the offer, but it's structured a little bit different. On Monday after we had the mission, Mr. Fields,
Is this whatever this stuff?
seriously, Monday, Monday night, about 9 p.m. on Thursday, Mr. Fields called me. Said, if there's anything that you can do, this issue is defensive. Will you please get talking? Is into the door.
Well, I don't see a lot of the.
How is the structure of it, yeah. So it is the plea to one count of armed robbery, which would be, if armed robbery would be commuted to time served under 1710, that's the.
So that's what y'all were conveying, that's.
And I gave him, he also asked, in lieu of that, can I have a straight number? That would be, that said, fully served. And that, I left it at the asked for a straight number, in lieu of, because it was going to be 20 served 10 on the gang charge, which would theoretically be eligible for parole. So it wasn't, I wasn't commuting everything. I'm sort of just on. I understand. Per day. And you would still have 20 days in the game.
510 days. Meeting on the robbery. I'll tell you all. We'll have it. And especially because we're going to be fine. All right. What was the offer for Mr. Gibbs? Oh, sorry. Yes, sir.
Your Honor, just for on a project,
You're fine with me looking at it, is it?
it will be free one time on 10 years served. And that will be released on all of the your debt. And that's it. 20 years, 10 years first. I would for totally that great. And benefit we get. Oh. That. Sure.
Thank you. What, yes, that's it.
That is my understanding. Essentially, Judge, is the same. That's correct. My understanding of the purpose of sentencing the citizen, would be, essentially, it's the same offer subject to the party on robbery. So when you serve on the gaming charge under the whole statute, so different, role eligibility. In addition, we're also briefly, let's say, but, an alternative, there's also, where there's an alternative, which would be a 27 still a subsection to the question, but it would be some number in between 1 and that would be solid. Of course, there's no probability. Okay. That's the other. We also have to say, non-negotiable.
And Mr. Ferguson would represent nine. All right, and what is Mr. Gibson, if he was unsuccessful trial,
Your Honor, these convicted of the armed robbery counts as mandatory life without parole.
if listen, I'm going to this, the doctor, that Mr. Gibson was looking at if he
Life without parole. Life without parole plus 75. And if he is convicted of armed robbery, it is mandatory life without parole. And the court does not have any discretion. The court must sentence him to life without parole on the armed robbery.
Mr. Gibson has 3 prior.
Correct, Your Honor.
Mr. Have you advised All right, so Mr. Gibson, you understand that you are charged with count 1, 2, yes, that's something. Count 1, violation of the Street Game Fairwood Act. Count 2, violation of the Street Game Fairwood Act. Count 4, violation of the Street Game Fairwood Act. Count 5, violation of the Street Game Fairwood Act. Count 6, violation of the Street Game Fairwood Act. Count 8, violation of the Street Game Fairwood Act. Count 9, violation of the Street Game Fairwood Act. Count 11, violation of the Street Game Fairwood Act. Count 12, violation of the Street Game Fairwood Act. Count 14, violation of the Street Game Fairwood Act. Count 15, violation of the Street Game Fairwood Act. Count 17, criminal offense. Count 18, armed robbery. Count 19, aggravated assault with a deadly weapon. Count 20, aggravated assault with a deadly weapon. And count 21, possession of a firearm with a conviction. So you understand that those are the counts with which you can talk. All right, if you keep your voice up for me, thank you. That's what I'm here. All right, so you understand that if you are unsuccessful because you have been facilitated by the state, that if you are unsuccessful in that, this is under A and C, is that correct?
Yes, Your Honor.
All right, so that means that the court will have no discretion, that you will have whatever counts your, I guess, yeah, one thing. And you understand that if you are found guilty of all of the counts that I've discussed with you, that would mean that the court would have no discretion, but to sentence you to a minimum of life without life without all because armed robbery carries that penalty of you understand that? All right, for the aggravated assaults, the court would have no authority to go below 20 years. You understand? You understand that? All right, And you understand that for the gang counts as well as the murders and the gun counts again, it'll be the next. If you have to any of them. You understand that the court has the course to run, the sentences consecutive, however, the court can also run them concurrent. Consecutive means each charge will follow each other. The current means that you can serve on have you had the opportunity to discuss the state's offer with Mr. Lewis? Do you need more time to speak with Mr. Lewis?
Sure.
All right. Okay, I'll give you that opportunity, sir. You can have a seat. All right, now we go to Mr. Lindsay. Mr. Lindsay, what is the offer? Am I saying that it correctly? Okay. May I show me what?
Your Honor, somehow others.
Okay.
I'm borrowing my name.
Okay. Um, so what's the offer for Mr. Lindsay?
The offer that's made to Mr. Lindsay, was the, 20 to serve 10 on game count, as well as a 20, as well as the, 10 years community time served under the subsection E on armed robbery.
Okay, Mr. Lindsay, as of yesterday, served 1,440 days custody, which is approximately 3 years.
It would be 4 come up with it.
Right, so Mr. Lindsay has served approximately 4 years. All right, and Mr. I heard you say that he started to talk with you, had the opportunity.
That's correct, Your Honor.
All right. And he's facing the unsuccessful.
He was, this is including murder, he was convicted of everything. The maximum sentence is life plus 275 years.
All right, Mr. Lindsay, you understand that the maximum penalty you are facing if you go to trial is life plus 275 years of that. Pick up for me.
Yes, ma'am.
All right, you understand that, certainly the state has conveyed an offer, and even if without that offer, you have the opportunity to go down and negotiate. You understand? Same for you, Mr. Green. All right, so have you had enough time to speak with Ms. Leon about, your decision to proceed to trial?
No, ma'am.
All right, I will give you all that opportunity. You can have a seat. All right, let me be very clear with all three. Be advised, Mr. King was for the United States.
So I didn't count the merger last time. And if Mr. King was, convicted of everything, he would be, facing life plus 375. It includes the merger.
What did I say? I said 302.
It was, on Monday, it was 395, but and then it was, there's a.
Got it. Mr. King. Sir, you'll recall the conversation that we had on Monday on the record regarding the max that we're facing. All that? Yes. Okay. And on Monday, I was advised that, the maximum you think was not considered the question. Now, you recall that? Yes. All right. I'm sorry, okay. They have since advised me that it's actually 5 plus 375 years after. You understand? Yes. All right. I know it may seem like it's not a big difference. All right. All right, well, so, it is 9:53. I'm wondering how much time do I need to talk to client, because I need to file the work down, and in case it does, set down, or over. So, let's see. Let's start with skill, because I don't really know if it's
45.
45 minutes, that puts us at probably where that is.
Yeah. It's good. I don't know. It's good.
but I also want to take the step that you have to very, very clear. What I would accept and stop. Okay, and in fact, I had to change requests, the videos that go forward and ten. So, we're not gonna be 45, but I was leaving from the doors.
You're not allowed to do 30 minutes.
30 is reasonable.
Alright, so I will give you all, 30 minutes to, discuss everything with your client. Before I do that, let me go to the your questions. I can start with Mr. King's, well. Why your question was, are there any objections from the defense? Against logistics, standpoint, I have all the so any objections from the council to the same proposed document? All right. Objections to any of the same proposed document?
Judge, I'm actually trying to put it.
There's any objections to Mr. Queen's proposed one-year?
Yes, I do have some objections. I specifically have objections, to the questions, I believe it's 21 through 23. Apologize, Your Honor. I have objections to the questions, has anybody felt necessary, to dissolve?
Good question. This 21 is how many of you own a gun or have a gun in your home that
Oh, yes. I'm sorry. It is, 23. How many of you have ever felt you may be in danger when you see a private citizen near you in a store carrying a gun? That's critical. Three times. My other objection is Great. Experience.
well, that's a different question. Here, this one is, have you ever felt it? So I will, the question for you.
I'll answer what is my question for you. So the book. Very good back. There's a fine.
All right, that's on the last one.
I think you see that question just get into the literal facts of the case. I'm not having an objection to the general, does anyone feel that it is against, one way or another about self-defense? If you have any objection, you feel that people have the right to defend themselves, that is fine. There's a general question. If you get specifically into disarming people, and
Well, that's not perfectly clear. Let me tell you what that's- whether it's not clear. This is about-
I'm watching you, Judge. I'm watching you.
all right, 23. How many, I just feel that, in general, who has a fear of guns? I think it's,
So that's question about the act.
I think you can ask who has a fear of guns, but when you get so specific, if you're a private citizen carrying a gun, I think it encompass, and it's just the general, who has a fear of guns.
All right, I'm going to overrule that step. First, you have the authority that says opposite. Here, the question is, how many of you have ever felt that you may be in danger when you see a private citizen near you or carrying? That question is not good, but it's not. I do think that. All right, then walk and go as necessary. Next one.
I would object to the question 24. Has anyone ever felt compelled to disarm someone with a weapon, if they fire or knife, if it's a concern, for the safety of yourself or others? Then, that's in the field that is going into the back of the case. I think it's okay.
I don't know what the big argument is, if you're assuming that.
We've had two new information in that part of the record, and that there's conditions made in the motion. I mean,
The part.
well, I did. Okay. It leads into the, I, to your point, I will note my objection to the record. That I feel like goes into the back of the case.
So there's an authority that says that you can't ask questions that part of your part. You can ask questions that go to, certainly the fact of the case, but not something that requires the ask of your judge. So that's what I'm asking about, how does that question have to do with to judge the case versus getting their feelings, only biases in advance? That's, now, again, Mr. Steele very crafty in how to phrase that question. Had he gone further, which when we worked with I would completely agree with you, but the way it's phrased is asking for their opinions, biases, et cetera, and form out themselves and tailor to the specific subject.
I would just respectfully disagree and I will honor the court's decision. I don't have the authority. I think it goes further in the court does.
Also, I would ask them to prove this,
Because it's the specific fact. It is, I think, a general self-defense or defense of others. Has anyone ever felt the need to defend others or themselves? When you start adding specific facts that are come out, this person who was in line was disarmed of their gun.
that's not the question. Or specific question. Like it limited to limiting. Now, he asked this question, that's also why I said this too. That's what I'm gonna take it. Question asked. So again, this question is that anyone ever felt compelled to disarm someone of a weapon, such as a firearm or knife, because you were concerned with the safety of yourself? How is that question prejudging for?
I
It doesn't mention anything at this point. I'm assuming what your argument is that. I was involved in that case, so.
understood. I understand.
All right. So that is a rule, question 75. What's the issue or solution?
There will be the same objection, and I will. I don't have any. I feel it is good.
25. Has anyone ever seen someone disarm another person of a weapon, such as a firearm or concern for the safety of his or herself or, right? What's the next one?
That's the only check.
To all of this question. So let's now go to the request, the one-year questions for Mr. Lindsay. Any objection?
My objection to Mr. Lindsay's questions are in the form of all the questions, a statement first. Um,
Right, so, Mr. Lindsay, so that's Mr. Young, Mr. Young, so you have to ask a question, so we arrange how they are asked.
So I've arranged them in like a polling, formatting, because a lot of
I
times,
understand, I find that to be confusing to the jury. So like, for instance, when you hear me ask the question, you'll hear me say, please raise your card. Follow. Because the way you have the phrase, there are people who believe that once the case is decided, that person charged must be guilty of something. If you agree or strongly agree with this statement, raise your card. Versus saying, please raise your card if you believe that.
I'll change it.
Okay? Any other objections to this?
No, I think all the questions to make a statement first. I think as long as they're asked, like for question 2, are there people who feel, that society focuses too much on race? I feel that is an appropriate question for what year my objection.
It's not.
No, it is. I think it is. My objection is just to the form of the statement. There are people who feel like society focuses too much. If you agree from.
He's already said it's just the phrase, but person why that.
I don't have any other, I don't have any objections. That was my objection to just to the.
All right. And then with regard to Mr. Gibson's, what your questions, any objections?
No objection.
Okay. Any objections by either the defense counsel or any other questions, other than?
I don't have any objection regarding Mr. King's or Mr. Gibson's, Your Honor, and I've had an opportunity to review the state.
Okay. Okay. Mr. Lewis?
There's no.
All right. And now back to you. Any objections to the state's, proposed budget?
No, Your Honor. There's no.
All right. All right. So, before I forget, anything else I need to pick up before we take our.
Not from the state. Your Honor.
Not from this one, yeah.
No,
All right, please make sure to walk the room, when it's a clear room before we come back. So, you'll. But, all right, now, Mr. King has specific positions. We feel need to turn, which is probably put him right there, but if you feel like it needs to be moved, Mr. Field, just like we started brown or the goods, and then they will.
Yes.
Okay. All right.